Hi friends, Tony DeWitt here, Missouri appellate attorney and a guy who likes to make the law make sense on YouTube. Here's what we're discussing today. One of the things that I don't think people appreciate is that very much like certain kinds of pants and shirts go out of style and other newer, different designs come into style, there are movements like that in the legal system as well, and a lot of it is driven by the public's reaction to a particular issue. And of course, one of the big issues right now, alive and active in the country, is that of immigration, and particularly illegal immigration. To recognize that our immigration system is completely broken is not to take a side one way or the other. It doesn't work. The system that we have for dealing with individuals who cross our border and remain here unlawfully has so far proven to be completely inept at redressing the kinds of problems that we have from that. While you wouldn't think necessarily that somebody crossing our border illegally would have a champion in the legal system here, while you wouldn't necessarily think that somebody crossing our border illegally would have a champion here in the United States, there are numerous non-governmental organizations that employ scores of attorneys specifically to argue on behalf of illegal immigrants and illegal aliens. And as a result of that, there are a number of ways that people can sort of beat the system. And one of the ways that they can beat the system is through challenging what's called a notice to appear. So there are two kinds of people who are here, illegal aliens. There are two types of status. One is somebody who is removable, and one is somebody who is not removable, usually because they have petitioned for asylum, and that asylum has been granted. And of course, once that asylum has been granted, then in most cases, their status moves from being here unlawfully to being here lawfully. There are lots and lots of people who come here illegally who do illegal things and wind up getting flagged for removal. But there are also a lot of people who come here illegally, live out their lives quietly, obey the law, work hard, often work in really awful jobs like chicken processing plants. They deal with stench and aroma. I mean, they basically wear clothes that can't really ever be purged of the smell of a chicken plant. Those poor people work very hard, and I believe they are due some empathy and respect. But in spite of that, the law has absolutely no regard for anything other than lawful or unlawful. And if you are lawful, then you get the benefits, and if you're unlawful, you usually do not. Well, we have a Supreme Court case here today that we're going to look at that deals with illegal aliens and with their removal. It begins with a part of the process. I'm not going to go through the entire opinion because the entire opinion written by Judge Alito is very scholarly, has a lot of different case citations to it, and I think is a very well-written opinion, but it would simply take much too long to get through it. So I'm going to go through the syllabus of the opinion, and then we're going to look at the dissent that was joined by 4 justices. So this is a 5-4 decision. It's called Compos-Chavez versus Garland, Attorney General. So here's the setup. To initiate the removal of an alien from the United States who is either inadmissible under 8 United States Code Section 1182 or deportable under Section 1227, the federal government must provide the alien with written notice of the proceedings. That's Sections 1229A, 1 and 2. 2 types of written notice are provided. Paragraph 1 provides the alien must be given a written notice to appear, or NTA, which must set out, among other things, the time and place at which the proceedings will be held. Paragraph 2 states that in the case of any change or postponement in the time and place of such proceedings, the agency must provide a written notice specifying the new time or place of the proceedings and the consequences of failing to attend. An alien who fails to attend despite having received notice shall be ordered removed in absentia, which means you don't even get to show up and contest it, that when they catch you, you're going back across the border. In this situation, 3 scenarios permit the rescinding of an in absentia removal order. So let's say that you don't show up, they issue this order, and now you want to get it rescinded. 3 scenarios permit the rescinding of an in absentia removal order, one of which is when an alien demonstrates that he did not receive notice in accordance with paragraph 1 or 2. In these consolidated cases, 1 from the Fifth Circuit and 2 from the Ninth, aliens Esmelis Compos-Chavez, Varinder Singh, and Raul Daniel Mendez-Colin each moved to rescind his in absentia order of removal on the ground that he did not receive proper notice of the removal hearing. In each case, the government provided an initial NTA, or notice to appear, but the NTA did not specify the time and place of the removal hearing. Eventually, the government provided each alien with a notice of hearing under 1229, which set out the specific time and place of the removal hearing. So to be clear, what you have here on the left is a notice to appear that gives the name of the removal person, but not the actual specifics of the time and date of removal. And on the right, what you have is the actual second notice, which provided all of the information that was required to be provided by the statute. And as a result of that, the persons who were so notified had proper notice of the actual hearing and date and time. None of the aliens showed up for his hearing, and each was ordered removed in absentia by an immigration judge. Each then sought to rescind the removal order, arguing that he did not receive a proper NTA. The Fifth Circuit considered and denied one of the petitions, but the Ninth Circuit granted the other 2. Here's what the court decided. Because each of the aliens in this case received a proper 1229A2 notice for the hearings they missed and at which they were ordered removed, they cannot seek rescission of their in absentia removal orders on the basis of defective notice. These cases turn on whether Compos-Chavez, Singh, and Mendez-Colin can demonstrate that they did not receive notice in accordance with paragraph 1 or 2 of section 1229A. The government reads that provision to permit rescission only when the alien did not receive notice of the hearing he failed to attend. The Compos-Chavez, Singh, and Mendez-Colin, on the other hand, urge a reading of the provision's word or that would distribute the phrase did not receive notice in accordance with across paragraph 1 or 2. They argue that because each can demonstrate that he did not receive an NTA, they can each seek rescission of their in absentia removal orders. The government's provision of a single notice under either paragraph 1 or 2 defeats rescission under the statute. The word or is almost always disjunctive. Thus, 1225B's ordinary meaning is that either paragraph 1 notice or paragraph 2 notice can count as notice in accordance with paragraph 1 or 2. Statutory contexts point in the same direction. Furthermore, subparagraph A requires the government to establish that it must provide the written notice, indicating that only one single notice must be provided in a single document. So here's what the deal was. They did not receive an initial notice to appear that specified when their hearing would be. They got a notice to appear that basically said there'll be a removal hearing, we'll get back with you as to a date and time. And then later on, they got a second notice saying, this is your removal hearing, you got to show up. If you don't show up, you'll be held to be removable. You won't have any grounds to rescind your notice. So they didn't show up. They sought to overturn that decision, and the Supreme Court here says, look, you got notice. You got notice of when the actual hearing was going to be. You certainly didn't get it at the front end, but you did get it on the second paragraph part there. You got it when the new time and date were given to you. You can't complain that you didn't have notice. And that's essentially what the issue is here. And what the court says is Compos-Chavez, Singh, and Mendez all received notice in accordance with paragraph 1 or 2 for the hearings they missed, and thus their in absentia removal orders may not be rescinded on that ground. The government concedes that none of them received a compliant NTA. Each did, however, receive a notice in accordance with paragraph 2, and each notice met all of the requirements for a notice under that provision. After receiving a defective NTA, each alien received a notice that provided a specific time and place for their removal proceedings. Those notices provided new times and thereby changed the time and place of their removal proceedings within the meaning of 1229A2. So they reversed the Ninth Circuit and they affirmed the Fifth Circuit, and that's the way it went. But there was a dissent written. It was written by Judge Jackson, and it was joined by Sotomayor, Kagan, and Gorsuch. And you wouldn't think Gorsuch would be in there since he's a much more conservative judge, but I think he sees the same problem here that Judge Jackson does. And let's look at the dissenting portion of Judge Jackson's opinion. So this is the dissent by Judge Jackson. And she says, for years, the government has failed to ensure that one form of required notice, a notice to appear, hereinafter the NTA, contains all the information the statute mandates. Specifically, the government has issued NTAs that lack the exact time and date of a non-citizen's removal hearing. This conspicuous omission has twice before garnered our attention in cases concerning a non-citizen's plea for discretionary relief. And twice over, this court made clear the government issues an NTA, that document must contain the time and place particulars the statute requires. Today's cases, however, arise because the government persisted with its practice of issuing facially defective NTAs in the wake of our two prior pronouncements. But apparently, the third time is the charm, for now the majority has finally blessed the government's abject noncompliance with the statute's unequivocal command. The court concludes that a non-citizen whose NTA does not contain the time and date information required has no recourse from an in absentia removal order if the government subsequently provides some follow-up notice identifying the time and date of the proceeding he missed. So what we have here with Judge Jackson is it's essentially a form over substance sort of argument. It's like the statute requires that you do it, that you provide an NTA that has the date and time. And then it allows you the second NTA to change the date and time. But it seems to me that if you don't give them an initial court date and then you later give them a notice that has the court date, you haven't complied with the statute and they should not be removable. That is her argument here, and it has some facial validity, but you have to realize that the real issue, the real constitutional issue here is notice. Did the person get notice of the date and time of their hearing? And here it is undisputed that they all got notice of the date and time of their removal hearing. They missed it, and now they throw themselves on the mercy of the court saying, oh gosh, we missed it, but you didn't give us this first one, so that ought to cancel out my error in not getting to the removal hearing. And I don't think that's going to work. The attitude in this country is that illegal aliens, and particularly people who cross our border unlawfully, are given way too many breaks and are not held to the same standard that a United States citizen is held to. And I think that has, from a social point of view, even without necessarily saying so, the court, I think, feels pressured here to stand up and say, no, we need to rein this in. If somebody misses a removal hearing and they had notice of it, they need to go back. That's essentially what the court decided. Do you agree with the opinion? Do you think it's good? You can certainly get this off of the Supreme Court's website. It is located on the website. It's number 22-674 and 22884. You can find it on opinions on June 12th is when it was issued. So if you go to the Supreme Court website, you can find this opinion and read it all the way through if you want. It's an interesting opinion, but there isn't really anything in the body of the opinion that is more important than what I went through here. So I'm saving you a little bit of time by doing it this way. If you have any questions, drop them in the comments down below. Like, share, subscribe, all the things we ask you to do. I take no position on whether or not the court made the right decision here. I'll leave that to you guys. And if you have the opportunity today, do something nice for somebody. And until next time, come on back and catch me at the beach. If you like this video, here are a few others you might try, and don't forget to subscribe. Have a terrific day, guys.